So when the color of the refrigerator has to brought to be into existence, I have specifically mentioned to that particular person that the refrigerator must be of black color only. So at this stage, what we have to see, we have to see that all the terms and conditions of this particular contract has to be expressly mentioned. And if a particular person is expressly mentioning all the terms and conditions, then that particular contract has to be performed in that particular manner or that particular fashion only. So that particular contract, if it is of an express nature, which can be either in form of in writing or it can be form of a word of the mouth. That is, you can expressly tell that particular person orally also. Second concern or the second example of the types of mode of formation of the contract is the concern of implied contract. Now, implied contract is a particular contract is a particular type of contract wherein you do not expressly tell, we do not speak, we do not write anything, but we perform certain actions. So based on that particular action, the contract is said to be into existence, and accordingly we undergo that particular contract. So outcome of any act. So outcome of any act in the sense, either you are waving off your hand, either you are making certain actions, either you are making certain gestures, and based on these particular gestures, what happen, you understand or you come at a certain position about the contract that is there into existence. Now example, for example, you are standing at a particular bus stop, and whenever you stand at a particular bus stop, what happen, we want to see that a particular bus has been passing by, and you want to see that the bus stops at that particular bus stop and you board that particular bus. So in order to board that particular bus, what do? We do not shout aloud. What do we say? We show off our hand, and based on the hand that is being shown to that particular bus driver, he stops the bus at that particular respective bus stop. Now, which type of contract it is? It is a type of an implied contract. Why? Because we have done a certain act to that particular contract to be performed. We have not expressly told, we have not shown something in writing to that particular bus driver, and we have not said him to stop that particular bus. But what we have done, we have showed we have wave of our hand, and accordingly, on seeing our hand, what happened? He has stopped that particular bus at that particular bus stop. So based on this, what happened? A contract is said to be of an implied nature, wherein at any stage or point of time, if you are conducting any activity or any gestures or any behavior due to which a particular contract is said to be accepted, due to which a contract has came into existence, then that particular type of contract is called as an implied contract. Another example, hospital. Now, for example, at any stage, if you enter a particular hospital, it is an implied condition that at every stage or point of time, you will be paying the hospital bill that has been incurred. There is no certain condition that you will not be paying. You will be paying 50% amount, 30% amount, 10% or 90% amount. Any amount that has been charged by the respective hospital, it is an implied condition that you have to pay all the expenses. Whether you will be paying that particular expenses or your insurance company will be paying that particular expenses, that thing is apart. But the bill that has been generated by that particular hospital, each and every amount has to be paid by the respective service taker. So it is an implied condition with respect to the payment terms and conditions that is there into existence. So the first explanation of the express contract and second explanation of the implied contract. Next concern is the concern of quasi contract. Quasi contract, that is, quasi contracts are with that different types of contracts wherein the parties to the contract does not have any interpretation. The parties to the contract does not have any intention to enter into this particular contract, but with the virtue of law, with the law into existence, the relationship has been created in such a way that there comes into a certain position or picture about the law has come into existence. So quasi contract is that particular type of contract wherein the relationship is being created by the virtue of law. The law has been into existence, the law has been into enforceability, and based on this particular enforceability, based on this particular presence of the law, the parties to the contract has entered into this type of contract. For example, there is a particular trader, and that is now there are particular two families, family A and family B, and they are residing nearby to each other, that is besides each other in a particular flat. Now, after a point of time, what happened? Family number A, they have ordered certain goods and services on Amazon, and based on this particular order that was been placed on Amazon, what happened? A family went to the certain shopping or a certain leisure time, and they accordingly they were outside in the evening time, that is around 4:30 or 5 p.m. After a several point of time, the vendor of that particular Amazon delivery boy gave a call that I have came with the delivery of the goods, and accordingly, where should I deliver? You were not at home, and then what do you say? That is, the family A says to that particular delivery boy that the family B is into existence. You can knock their door, and accordingly, you can deliver those goods and services to family B. Now, at this stage, initially the contract was between family A and Amazon, and accordingly, there was no existence of family B into existence. So after a several point of time, if the absence of any one party is into existence, and based on the absence of one party, if some another party, that is party number 2, party number 3, party number 4, if they're performing their promises, if they're acting on your behalf, then accordingly there is certain type of contract, and that particular type of contract which is into existence is called as an quasi contract. So here what do we understand? Initially the contract was between family number A and Amazon, but after a several period point of time, with the virtue of law, with the change in the circumstances, with the change in the terms and conditions, with the change in the goods, with the change in the criteria, what happened? Family B came into picture, and accordingly family B signed on behalf of family A, and accordingly the goods was been delivered to family B. Now, who are the new parties to the contract? The new parties to the contract will be family B and the person of Amazon, that is a delivery boy, who has delivered those goods and services. How this contract can be completed? Now, this particular contract can be completed only when the family A returns from the shopping, that is from the market, back to their home, and family B will return the goods and services that has been delivered to family A. So if the goods have been essentially, effectively, and in full transferred from family B to family A, then accordingly we can say that the contract has been completed, the contract has been complied. So all terms and conditions and the validity of the contract has been fulfilled, and accordingly the contract comes to an end. So in this way, on the basis of mode or formation, the contract can be an either express contract, a contract can be an implied contract, or it may be an quasi contract. Later, after several point of time, you have a detailed description or explanation with respect to quasi contract into existence. Now, next first type we have seen, first composition, that is on the basis of mode or formation. Now going to the second perspective, that is on the basis of performance. So on the basis of performance, the contract has been divided into 5 types: executed contract, executory contract, partly executed and partly executory, unilateral contract, and bilateral contract. First type of performance is executed contract. Simple definition, where both the parties fulfill their respective promises. So at any stage, whenever there is a contract into existence, what do we see? If a contract is into existence, there must be an agreement. If an agreement is into existence, there must be a certain promise. And if there is a promise into existence, there must be an offer, and then that particular offer must be followed with an acceptance. So the sequence is first you have an offer, then the offer has been converted into acceptance. The acceptance is converted into agreement. The agreement has been converted into a particular contract, and then the contract has been performed by the respective parties. So at every stage or a point of time, what we have seen, there are certain parties that have been involved into this particular contract, and each and every individual party has to perform their promises respectively. Now, on the basis of performance, now we have to understand when the contract is been completed. Right from the beginning, that is the beginning of the contract was the offer, and the completion of the contract was the concern of performance of the contract by the respective parties. Now when we can say that the parties have performed their promises respectively, when both the parties to the contract, if there are two parties, then both the parties, and if there are several number of parties, if all the parties to the contract have performed their promises respectively, all the liabilities, all the duties, all the rights come to an end, then that particular type of contract is called as an executed contract. Executed contract is that particular type of contract where all the parties to the contract have performed their promises respectively. Example, I went to a particular shop and I said him that I want to purchase 5 kg of sugar. Now, whenever I quote this particular quotation that I want to purchase 5 kg of sugar, what that particular person will do, he will go to this particular storehouse, and accordingly he will pick up a particular bag. In this particular bag, the 5 kg of sugar will be weighed. That particular weight will be kept on the weighing machine, and accordingly he will pack that particular sugar and he will deliver on the cash counter. Now, whenever that particular bag of 5 kg of sugar is brought on the on the cash counter, what do? I remove my wallet and I pay him 200 or 500 rupees, whatever the amount that is been expended, or whatever amount that is being charged. After a point of time, what happens if the particular amount is being settled? Whenever that particular payment is made, I take the possession, I take the delivery of the goods and services, and I come back to my home. So here at this stage, what happened? Both the parties, which are the two parties? First party, that is myself. I have entered into a particular shop, that particular grocer shop. I kept a particular order, a particular offer was been given, that was been accepted. The goods was been delivered to me, and based on that particular delivery, the payment to the interested party was been done. I received 5 kg of sugar, and the particular vendor or that particular seller received the payment of rupees 200 or rupees 500. Based on this concern, what we can understand, both the parties have performed their promises respectively. So if both the parties to the contract are performing their promises respectively, then that particular type of contract is called as an executed contract. Second example or second type of contract on the basis of performance is executory contract. Both the parties do not perform their respective promises. So at any stage or any point of time, if both the parties are not performing their promises respectively, then that particular type of contract is called as an executory contract, wherein the parties to the contract has yet to perform their promises respectively. Executed contract. I went to that particular shop and I placed him a certain order of rupees 5 kg of sugar, and that particular person has not yet delivered me the goods and services. So the delivery of the goods and services is not yet given to me, and accordingly, I have also not made a payment to that particular person, that is the retailer or the seller who is available at that particular store. So if I'm also not performing, or if that particular trader or the seller is also not performing, then accordingly, what we can say that there is a contract which is of into existence, and that particular type of nature of contract is executory contract. So if both the parties do not perform their promises respectively, then that particular type of contract is called as an executory contract. Next concern or the third type is the partly executed and partly executory contract. So both agree but do not perform their promises respectively. Now at this stage, for example, they are going with the same example or the same illustration that we are looking for. Both the parties now whenever when we can say that it is can be called as an partly executed or partly executory, when either one party of the contract is performing and other party is not performing. I went to that particular shop, I placed a particular order, and that particular order has been performed. He has started to perform these respective promises. So what does he do? He has went to his particular storehouse, he has went to his particular store, and accordingly he starts weighing the goods and services. In the same way, in the same fashion, I remove my wallet and I start counting the cash. 100 rupees to 150 rupees, 200 rupees, 250 rupees to 300 rupees, 500 rupees, and so on. So in this way, what happened? Partly executed and partly executory. 50% contract has been performed and 50% contract is not performed. So in this way, we can say the contract is partly executed and the contract is partly executed, wherein after a stage or after a several point of time, after several duration, the contract can be performed and the contract can be completed. Next is the concern of unilateral contract, and last is the bilateral contract. So unilateral contract is a particular concern wherein one party has performed the respective promises and other party has not performed his respective promises. Unilateral is a particular concern of an one-way contract wherein only one party, that is the either the buyer or either the seller, they are performing the respective promises, and the other parties to the contract, they are not performing their promises respectively. For example, continuing the same example, I went to that particular shop and I've already made a payment to that particular person. On the particular cash counter, there was a particular QR code scanner that was available, and accordingly, while entering that particular store, I have already made a payment of rupees 500 to that particular vendor. And at this stage, the goods, that is the 5 kg of sugar, is not yet delivered to me. So this particular type of contract will be called as an unilateral contract, wherein initially at the first stage, I have made a 500 rupees payment to that particular trader or to that particular seller, but the seller has not yet delivered the goods to me. So one party has performed his promises, but the other party has not yet performed their promises respectively. Then that particular contract is called as an unilateral contract. Last is the bilateral contract. Bilateral contract is a type of contract wherein obligation of both the parties remain outstanding or unperformed. Now, bilateral is a particular concern wherein you have started to perform the contract, but you have not yet performed any of the promises, and entire contract is still outstanding or still unperformed by both the parties or all the parties to the contract. I went to that particular shop. I placed order of a 5 kg of sugar, and accordingly, what happened? All of a sudden, the particular person started to weigh that particular goods, and all of a sudden, I get a phone call from my home that there is a certain emergency. Please come back to home. And without paying the money, without getting the delivery of the goods and services, I return back to my particular home. And in the same fashion, while weighing that particular 5 kg of sugar, he gets a certain phone call and he stops weighing the particular sugar. So what happened? Both the parties have not performed. Either he has not calculated 5 kg of sugar, and I have also not made the payment, and I've also not accepted the 5 kg of delivery of sugar. So in this case, what happened? The contract has started, the parties have started to perform, but due to certain terms and conditions, due to certain circumstantial evidences, the parties are not able to perform their promises respectively, and accordingly, the performance of the parties remain outstanding, the performance of the parties remain unperformed, and accordingly, the contract is at a standstill position. So this situation or this condition wherein both the parties are not performing their promises respectively and it remains outstanding or unperformed, then that particular type of contract is called as an bilateral contract. So on the basis of performance, we have different 5 types of contract which are called as executed, executory, partly executed and partly executory, unilateral and bilateral contract. Next thing, on the basis of forms of contract, third classification measure, these particular forms of contract are considered, or they are being defined into two forms. First is the formal contract and second is the simple contract. So formal contract is a particular contract which comes only on formation and no consideration is required. So there are several different types of contracts wherein there is no requirement of consideration. In the essential elements of contract, what we were saying, that consideration must be required. It is quite essential element of a contract. But from the eyes or but from the purview of the law, what we see, we can identify, we can see that there are certain different types of contract wherein the consideration is not required. So that particular type of contract is called as an formal contract. For example, to give an illustration of a type of an formal contract, you are a particular student and whenever you are traveling from your hometown to Pune, what happened? You ask a certain sum of money to your father or mother. Now, whenever you are asking a particular money, what happened? Your father and mother, you have given a certain quote, that is, Papa or Mummy, I need 5,000 or 10,000 rupees for my daily expenses. Now, this particular concern, whenever a particular amount is been quoted by a particular student or a particular child to his father or mother, at this stage, what happened? There is a condition of natural love and affection between the parties to the contract. These particular parties to the contract, they are of a certain condition wherein there is no formality that has been required. So we don't have to go undergo any formality or a certain concern of a writing or a certain format of either executed, executory, or a certain concern of the mode or formation. In this case, what happened? The parties can come forward and accordingly they can perform their respective promises. If the amount is available, the amount will be given, and if the amount is not available, the amount will not be given. And both the parties will not take any legal action on each one of us. So at this stage, what we have to see, we have to identify about in what way we are conducting the promises, whether the relationship is formal or whether the relationship is informal. So if the relationship between the parties is of natural love and affection, then at this stage, what we can say, we have to identify, we have to see that from the eyes of the law or from the purview of the law, the consideration is not required, and accordingly, this particular type of contract is called as an formal contract. Next example is the example of simple contract. So the different type of the classification is the simple contract. Simple contract is is that particular type of contract wherein all the essential elements of the contract have been performed, and accordingly that particular contract is called as a simple contract. A contract which is fulfilling all the essential elements or conditions of the contract, that contract is called as a simple contract. So no more explanation is been required for this concern. Now, lastly, very important perspective on the basis of validity or enforceability. These are the various different types of contract based on which you can identify whether the contract is valid or whether the contract is enforceable. So the contract, a classification of the contract on the basis of validity or enforceability, it has been divided under 6 categories. The first category is valid, void, voidable, illegal, unlawful, and unenforceable contract. First thing, valid contract. Valid contract is a particular type of contract wherein which perform all the essential elements of a valid contract. So if all the terms and conditions, all the essential elements of the valid contract have been fulfilled, if they are being satisfied, then that particular contract is called as a valid contract. Now here at this stage, you have already seen what is a valid contract. So essential elements of a valid contract. So if all the conditions, when all the following requirements are been fulfilled, that is point number 1 to point number 10, if all the 10 points have been concluded, if they have been fulfilled or if they have been complied, then that particular type of contract is called as a valid contract. What are those conditions? The conditions with respect to two parties, an agreement, competency, lawful object, lawful relationship, legal relationship, lawful object, lawful consideration, free consent, not specified legal void, legal formalities, and certainty and possibility of performance. So in this way, if all the conditions have been fulfilled, then that particular contract is called as a valid contract. Void contract. A void contract is a particular type of contract which is not enforceable by law. So which ceases to be enforceable. So at any stage or point of time, if you find out, if you see that a contract which cannot be enforced by law, then that particular type of contract is called as an void contract. Void contract, you have a different short note with these particular perspectives, and based on the purview of law, based on the definition that has been provided in terms of eyes of law, there are certain different types of contract which are specifically declared as void. There are several different types of contract which are specifically declared as void, and in the eyes of law, these particular contract are not valid contract. So a contract which is not a valid contract is called as an void contract. A contract which is not a valid contract is called as an void contract. In simple terms, as per the definition, a contract which is enforceable by law is a valid contract, and a contract which is not enforceable by law is called as an void contract. Third option or the third classification is voidable contract. Voidable or set of option at one party of the contract. Now, voidable in the sense it is optional for you at any stage or point of time. What is the condition that now certainty and possibility of performance gives you a certain condition or a certain liability or a certain concern about whether to perform or whether not to perform. So it is always at the option of the particular parties. Now, which are the two parties? Now, which are the parties? There may might be either two parties or there may be n number or several number of parties to the particular contracts at any stage, at any point of time, from the beginning of the contract to the end of the contract. If you found out that any one of the party of the contract is not performing, and if they say that I don't want to perform this particular contract, then that particular contract becomes voidable. So it is at the option of one party of the contract. If the particular party feels that I want to perform my promises, I want to undergo or I want to continue with this particular contract, then accordingly the contract can be continued. If the other parties feel that the contract is not to be concluded, it is not to be continued, then accordingly the contract stands cancelled, the contract stands unperformed, and accordingly this particular type of contract is called as an voidable contract. So voidable contract is a particular type of contract which is always at option to the party. Now, which is that particular party? That particular party is the party to the contract with to the voidable contract is never ever identified, and we cannot say which party is going to perform and which party is not going to perform. So at every stage we have to identify which party is performing and which party is not performing, and based on the performance of these respective parties who are parties to the contract, we can see whether the contract is voidable or whether the contract is valid or whether the contract is void. Voidable. I'll give you an example for a voidable contract. I went to that particular store, I went to that particular grocer shop for purchasing 5 kg of sugar, and after a several point of time, he has weighed a particular 5 kg of sugar, he placed it on the cash counter, and at the time of the payment, what happened? I found out that my wallet is missing and I have not brought any cash for payment, or card is also not available with me for payment. So at this stage, what happened? The person has performed his promises respectively. The vendor is ready to give 5 kg of sugar, but I am not ready to pay. I don't have 500 rupees to pay to that particular vendor, and accordingly, it is at the option of one party. If I am ready to make 500 payment, or if the particular person is ready to give me the sugar free of cost, then only the contract can be performed, and accordingly the promises can be fulfilled. But at any stage, if the party is not also ready to accept the question, if is not ready to give the sugar free of cost, and if I am also not ready to give 500 rupees, then at this stage what happened? The contract becomes unperformed, and accordingly it can be called as an voidable contract. Next is the illegal contract. So a contract which is against the law of enforceability or any other law will be called as an illegal contract. So based on the terms and conditions that have been provided in the Indian Contract Act, if any of the terms and conditions of the Indian Contract Act has been performed, but other laws, the terms and conditions are not been fulfilled, or if they are not been performed, then that particular type of contract is called as an illegal contract. So from the eyes or from the purview of the law, if there is no legal entity from the action that you undertaken of the contract or the contract or the agreement that you are entering, then that particular type of contract is called as an illegal contract. So any illegal activity that you are doing, drugging, smuggling, selling of goods and services which are harmful for nature, hazardous of the nature, that particular type of contract can be called as an illegal contract. Next concern is the unlawful contract, so which is called as the against the law of enforceability, only law of contract. So there are certain different types of contract wherein only the permission of the ICA, that is Indian Contract Act, can be given, but other laws of contract cannot give you certain permission to perform those activities or those conditions. So in this way, at that particular stage, that particular type of contract wherein the law of enforceability is into existence, but only law of contract can be applied and other laws cannot be applied, then that particular type of contract can be called as an unlawful contract. So in terms of the eyes of the law presumes to the contract to be lawful, but only under Indian Contract Act, but not any other act. So there is a slight differentiation between illegal and unlawful. Under illegal, the permission was been given by other law, but not given by ICA. In terms of unlawful, the permission is given by ICA, but the permission is not given by other law which are into existence. So in this way, that particular type of contract wherein other laws are giving other laws are not giving permission, but law of contract is giving you permission, then that particular type of contract is called as an unlawful contract. And lastly, unenforceable contract. So a contract which is not valid in any court of law. So whether you perform any activity, whether you perform any condition, whether you perform any agreement, which is not valid in any court of law, which is not permissible in any law that has been into existence, that particular type of contract is called as an unenforceable contract. So basic requirement of essential elements of a contract as per the definition of 2H of ICA is an agreement which is enforceable by law. So अगर enforceability है तो आपका contract perfect है, legal है, valid है. If there is no enforceability to existence, then at this stage we can say that the contract is not perfect, not legal, and not valid. Example, an unforeseeable contract, a contract which is not valid in any court of law. So any activity that has been dealing in terms of terrorism or any activity which is dealing for the harm for a particular nation. So any activity, if you are dealing with the perspectives of terrorism or harming any of the nation, any of the society, any of the individual of a particular country or a particular nation, it is not a legal activity in any court of law. It is not allowed in India also, it is not allowed in Maharashtra also, it is not allowed in any of the state of the India. It is not allowed in any other European country, American country, Australia, and so on. So any activity, any action that you are undertaking, any contract that you are entering, any agreement that you are signing, which is not valid in the court of law of any court which is into existence on this particular earth, that particular contract will be called as an unenforceable contract. Okay. Any difficulty at this stage for understanding the different types of contract or classification of contract? Quickly, just let me know. We'll take a short explanation.
Sir, I have a doubt.
Yes, please.
Sir, if you have a contract with another country and suddenly a war will break out, what will happen to the contract?
The contract is there into existence. Because you have at the time of entering into contract, there was existence of proper terms and conditions. So at this stage, what we have to do, we have to perform that promises respectively. But if there is a war situation and there are certain terms and conditions that after a point of time you can perform your promises respectively, then the contract can be performed. Now, good question. Now, after a point of time, if there is a certain relationship between of enemy, for example, a war relationship between India and Pakistan. So at this stage, if there is a certain situation or a certain condition wherein one party is located in India and another party is located in Pakistan, now at this stage, if there is certain relationship of enmity, war situation is accepted, but the war situation must not be of an enemy purpose. So if enemy purpose has been identified, if the consideration, if the object of the particular contract is not able to be satisfied, then that particular contract cannot be performed. So if the contract is performed partially, you have to perform the contract partially, and after a point of time, the contract will stand cancelled. So here at this stage, what is your purpose? What is your motive? It plays a very important role. At the time of entering into contract, if the contract is performed 50%, you have to perform in 50%. After a point of time, if there is a relationship of enmity, then on the basis of enmity, the contract cannot be performed.
Thank you, sir.
Yes. Any other? Either essential elements of contract or on classification of contract, on the basis of mode or formation, on the basis of performance, on the basis of forms of contract, or on the basis of validity or enforceability. Expressed, implied, quasi, executed, executory, partly executory, unilateral, bilateral, formal, simple, valid, void, voidable, illegal, unlawful, and unenforceable. Okay, moving with the next concept, that is offer and acceptance. So at initial stage, whenever there is a certain contract into existence, earlier I've explained you contract की definition आपकी reverse mode में जा रही है. What is that particular reverse mode? First thing, what do we see? We have understood what is contract. Second thing, we have understood what is agreement. After agreement, there comes consideration. After consideration, there comes offer, and offer is followed with an acceptance. So promise. So in this way, it is going in a reverse fashion. Accordingly, we have to study each and every individual situation step by step, one by one. So offer, section 2A of Indian Contract Act, that is ICA 1872, defines offer as when a person signifies to another his willingness to do or abstain from doing anything with a view to obtain the assent of that another person, such an actor, he is said to make an offer. Whenever we say a contract has been executed, a contract has been performed, what is the initial position? What is the first step in starting of that particular contract? That offer has been went from one person to another person. So here you see, when a person signifies to another his willingness to do or abstain from doing anything willingness to do, that is you want to perform or you want to conduct a certain activity, and if there is a willingness, if there is certain consent of your condition of that particular performing that particular activity, and if the another person is also giving that particular assent with a view to obtain the assent of that another person. So if another person is also giving you that certain assent or certain affirmation to that particular offer, then that particular condition can be called as an offer. So offer and acceptance goes hand in hand, and accordingly we have to identify, we have to see that whether if there is an offer, there must be an acceptance. If there is acceptance, there must be a promise into existence. If there is a promise, there must be an agreement, and if there is an agreement, there must be a contract into existence. So the person who makes the offer or the person who gives the proposal is called as promiser, offerer, or proposer, and the person who accepts the offer or the person who accepts the proposal is called as an promisee, offeree, or proposee. Short note, sorry, 2 marks question that can be asked for you the online exam for the 2 marks question in that is question number 1. Who is a person who can be called as an offer? So the person who makes the offer is called as an either promiser, offerer, or proposer, and the one who is accepting the offer is called as an promisee, offeree, or proposee. For example, I went to a particular shop and I have given a certain offer for delivering 5 kg of sugar. Now delivering, I gave a certain order. Now who makes the offer? The proposal. So what will be my position? I will be the promiser, I will be the offerer, I will be the proposer, and the seller has accepted to deliver 5 kg of sugar. So I went to a particular shop. I said him that please deliver 5 kg of sugar me, 5 kg of sugar to me. I'm ready to pay you 500 rupees. The person who accepts the offer or the person who accepts the proposal. So the particular seller, the particular trader, he has accepted to deliver 5 kg of sugar to me. The seller becomes proposee, offeree, or promisee. So in this way, the relationship between two parties can be identified, and accordingly we have to see what is the relationship between the parties, whether the person is proposer or whether the person is proposee, whether he is offerer or offeree or promiser or promisee. Example, A tells to B, I want to purchase your bike. A tells to B, I want to purchase your bike. Now, who is a proposer and who is proposee or promiser or promisee? Yes, anyone?
A is a proposal and B is offer.
Right. A is the proposer and B is the proposee or promiser or promisee or offerer or offeree. So the person who is giving, so A tells to B. So here at this stage, what we have seen, we have to understand that an offer. A is giving offer that I want to purchase your bike. So in this case, A becomes offerer or A becomes proposer, and gives his assent that yes, I want to sell my bike. So B becomes proposee or offeree or promisee. Clear?
Yes, sir.
Okay.
Yes,
It's 11:57. That's all for today's lecture. Thank you so much everyone for joining. I am posting the link of attendance in the chat box. Student to please mark your attendance.
Thank you, sir.
Okay. The link has been posted for legal aspects of business. Just someone give me the confirmation after your completion. Let me know when you have done. Akash. Okay. Thank you, Akash. Chalo. Thank you everyone for joining. See you at 12:15 for next lecture of economics.